Is Diddy trying to dox his accusers? Earlier this month, attorney Sean Busby announced that his law firm would be filing over 100 sexual abuse civil lawsuits against Sean Combs, aka P. Diddy, aka Puff Daddy, aka P. D, aka Love. And then earlier this week, they filed 6 of those cases. And others were filed by other lawyers before that, which led to this request being filed by Diddy's criminal defense team. Hey guys, I'm America's attorney. I've been a lawyer for over 20 years. I've helped over 20,000 people, and I am here to break down Puff Daddy's recent request just for you. Let's find out exactly what Sean Combs is trying to accomplish with this informal motion called a bill of particulars. As you know, and as I have said in my last 3 videos, P. Diddy is being accused by the government and by countless civil lawsuits of sex trafficking, sexual abuse, and racketeering. A trial date has been set for Diddy's federal charges, and it feels like every day we're getting new motions, new filings, and new America's Attorneys videos, so it's not all bad. Now, as I mentioned earlier, 6 new civil filings have been filed with the names of the plaintiffs remaining anonymous. This is similar to the federal indictment against Diddy, in which only a victim 1 was named in the second charge. No real names from other people, which leads us to the following bill of particulars from Diddy's team. Now, when you're accused of committing a crime by the government, you need to be able to defend yourself, right? You gotta be able to say, no, it wasn't me. If the allegations against you are vague or unclear, then it can be really difficult for you and or your lawyers to prepare for trial. And to make my point, let's do this little thought experiment. Let's say that you, dear viewer, are accused of stealing $5,000 from First City Bank, located at 123 South Main Street at 10:18 a.m. on May 2nd, 2024. Well, that's fairly concrete. And if you're going to defend yourself, maybe you can find video evidence that you were in the parking garage at your office building at that exact time, or maybe you were with other people, maybe you have an alibi. But what if, and I'm just being crazy here, what if the government accused you of stealing some money from some bank at some time in the last 20 years? It becomes much harder for you to raise a doubt about whether you couldn't have done that. And so it is with Sean Combs. The allegations against him are vague, and surely not all of his escapades this millennium were non-consensual or coerced, right? Surely not everyone who visited his house was trafficked there, right? In fairness, he needs the opportunity to know exactly what he must defend himself against. And of course, the way that pre-trial preparation proceeds is that he will need to have that information at some point. I mean, we all agree about this. But he's saying that he needs it now and not later. Keep in mind that his trial is only 201 days away from today. And that's really not that much time in terms of getting ready for trial, especially not in a racketeering case. Of course, in almost any other type of case, identifying the witnesses wouldn't really be an issue. Like back to the hypothetical bank robbery, you'd never see an indictment that left out key details of the robbery. But this case against Combs is different in at least 2 ways. First, the court system does its best to protect the victims of crimes, but especially of sex offenses. And so shielding the victims is a real consideration in cases like this. But more particular to Combs is the second issue, which is his celebrity status. Because he's very famous and very, very wealthy, the U.S. Attorney's Office might fear, and rightly so, that there could be reprisals against witnesses and victims who have been publicly identified. So what are the probable outcomes of Combs' recent request? Let's talk about scenario 1. Let's say the government takes a hardline approach and just says, because we only charged you with 1 victim, you don't need to know about the others. The court could sign off on that, but in that scenario, most courts would also tell the government that at trial, they can't discuss any allegations regarding people whose identities were kept secret. That's like, I don't know, common sense. And I don't see the government wanting to go for that in this particular case, because here they seem very intent on slinging mud. So let's look at a second scenario. the government agrees to some limited disclosure, which means that Combs's attorneys can find out the names, but only as closely guarded secrets. In fact, it would not surprise me if the government argues that Combs's lawyers can have the intel, but that they can't disclose it to anyone, including Sean Combs himself. Remember, the government has argued that he was trying to manipulate, intimidate, and influence witnesses in connection with their successful argument that he needed to be confined to a nasty jail prior to his trial. Of course, having Combs himself not know the names of these witnesses and victims alleged would be a pretty intense hardship on the lawyers, because one of the main ways that we as lawyers get ready for trial is by interviewing witnesses, looking at witnesses' statements, and comparing their stories. And if they can't talk about what they've learned with their own client, they can't compare the witnesses' statements with what Combs says happened, that could make a fair trial very hard to come by. So for now, we wait for a response from the Office of the U.S. Attorney and then the judge's decision. I'd like to know at this point, how do you see Diddy's motion going? Do you think it should be granted? Should the alleged victims' names be revealed? Should there be any limitations on those revelations? Drop your pro se opinion down below, and don't forget to lawyer up with me by subscribing. I'm going to be covering every step of Diddy's legal issues, and you don't want to miss it, and I don't want you to miss it. So there, we're agreed. Subscribe, bell notification. See you soon.